morning on this Friday, May 17th. I'm Stacey Delikat in for Jesse Weber, and thanks for joining us here at the Law and Crime Trial Network. It is a busy day ahead. We are watching 2 live trials today. All right, a little sidebar happening in court as the defense gets ready to cross-examine this witness, the sheriff who interviewed Timothy Jones after he was picked up and then went and found the children's bodies after Jones essentially led him and the other investigators to that site. I want to bring in my guests right now. David Schoen is a criminal defense attorney joining us live via Skype from Atlanta, and Joseph Scott Morgan, forensic death investigator from Jacksonville State University, also joining us live via Skype. Thank you both for being with us this morning, gentlemen. It's still early here. Let's talk about what we've heard, because this sheriff gave us a lot of information. First, about the demeanor of Jones after he was arrested in the 2 interviews they did, and also about the scene where they found these bodies. So, Joseph, I want to start with you because obviously this is a key part. We were looking at the aerial shots of where the children's bodies were found in those bags. How key is everything that happened from that point on in the investigation going to be when they found the children, when they found the bags with the bodies in them?
It is key because you only have the opportunity to enter onto a crime scene for the first time once, and so it's essential that you're well planned before you do this. And you know, these police officers, along with the defendant, had been out on the road for some time, and you know, their idea was just to try to find the children and to try to get over there to this, you know, this very isolated location. Part of what's really compelling about this case, Stacey, is the fact that it is a multi-jurisdictional event that's going on here. We have officers from SLED, that's South Carolina law enforcement investigation. We also have obviously the sheriff that's out of Mississippi and those investigators. And then you throw into the mix the Alabama authorities where these bodies are actually found. And you know, and not to mention the FBI is involved at this point as well. So to get all of those people, you know, on board at one time to try to marshal their forces and process the scene is a nightmare. I was encouraged to hear that the sheriff, once they had located the bodies, he said it was time for me to just back off. I wanted to get the prisoners secured, and they just left at that point in time.
Certainly, I agree with you, Joseph. Let me bring David in, and let's talk a little bit, David, about what the sheriff was describing in those interviews he did with Jones after Jones was arrested. The defense here obviously seeking to prove that the defendant was insane at the time of these murders, that he acted out of rage, that he had schizophrenia. From what we heard from the sheriff as he talked about the defendant sweating profusely, saying some strange things, reaching over to almost strangle his father, who was also in the interview room. What can we sort of read from his testimony, and do you think that helps the defense at all in trying to prove a defense, an insanity defense?
That part of it helps, the things that you've described. However, I think if I were the defense counsel in this case, I'd move away from the sheriff. He's a pretty good witness. And remember, my theory of the case as the defense lawyer has to be focusing on the mental health. This interview post-dated the killings by quite a while. What this defense lawyer needs to show is that the defendant suffered from insanity, or in this case, he claims schizophrenia at the time of the crime. The problem he has in this case a bit is that South Carolina also recognizes this a verdict of guilty but mentally ill. And so South Carolina operates under what's called the Manhattan Rule for the insanity defense. They have to prove, the defense has to prove, it's an affirmative defense, that at the time of the crime, this defendant, Mr. Jones, was unable to distinguish between right or wrong. If the jury were to find he could distinguish between right or wrong when he strangled these kids, beat the kid, etc., but he acted out of what they call an irresistible impulse, then he's guilty but mentally ill, and he's got a big problem. So I would move off of these things. I'd want to focus on the mental health part. The prosecution's doing its job. They've got to lay the groundwork here, and maybe the defendant gets a freebie. You know, Joseph described the complications of the forensic analysis here. He's right. I mean, you've got a lot of different agencies with different protocols. There's an opportunity for the defense to find a slip up here. However, I don't think that's going to be the defense theory, that there's anything, forensically wrong here. I'd want to move away from these cold hard facts and get on to the mental health part of the case if I were the defense lawyer.
Yeah, and I know, as we see in many of these cases, we have another case right now with an insanity defense up for consideration. It tends to be a war of the experts between which mental health experts the jury believes. But I want to walk back just one second to something else that we heard from that sheriff, which was about the defendant profusely sweating and the use of the drug spice, the synthetic marijuana. We've heard stories certainly from all over the country of people using this drug and acting out. Will the use of this drug possibly play a part here? I mean, is it possible that the drug very much caused his behavior? Joseph, do you want to weigh in on that?
Well, you're right. There are all these stories that run wild all over the country, and I'm not saying that they're not true, but let's consider just for a moment: was he under the influence of this drug when he decided to commit these crimes? Was he under the influence of this drug when he's making the decision to dispose of these bodies and he's running about the countryside? And that's key. The sheriff talked about this behavior, profusely sweating. He's in an irritated state. Those are some of the things that you see with spice. You'll have hallucinations, hyper anxiety, if you will. They'll get heart palpitations many times. That can explain the profuse sweating. So it doesn't have the standard mellowing effect on many people that you see with just standard THC that's found in organically grown marijuana. This is a synthetic drug. It's very, very dangerous, and so this could have an impact. I'd be very curious to know if there is any evidence that he had this in his system. Was he screened for it in any way? I think that could be impactful as well.
David, yeah, go ahead.
I just want to jump in one thing. The juries generally, as you well know, are loath to find a defendant, especially such a heinous crime as this, not guilty by reason of insanity. So it's a very heavy burden, practically, the defendant bears. To introduce into this the element of sort of a voluntary intoxication using spice makes it even more difficult. Plus, it runs the risk of making unclear the defense in the case. The defense theory has to be consistent. If it's schizophrenia, then it's schizophrenia. If it's that spice complicates the schizophrenia, that may be able to be worked in, but he's got a very heavy burden here, and the jury doesn't like the idea that a defendant voluntarily administers a drug and then claims some lack of culpability for the murder. Yeah. Yes, technically it can knock out the intent element of a capital murder like this, but I would be surprised if that's the way the defense is going to go and ask them to also find him to be insane. You're sort of now just throwing out there a couple of issues for the jury and say, gee, this is a man who strangled 4 kids, beat another kid, but we think you should show some sympathy because he was using a spice.
Yeah, I mean, I absolutely agree with you, and we don't know that the defense will try to, play up the spice element of all this. Certainly, of all of the cases we've heard of people acting out on spice, it doesn't mean that makes someone kill 5 people, let alone their own children. So there's certainly a lot to consider there. Did you want to add something, Joseph?
Yeah, I wanted to make a quick statement, kind of dovetailing what David had said. I think that this is a compelling point in that we still, this idea that he had a list of tasks that were laid out that was found, with some of this other associated evidence, not to mention the images of these bleach-stained floorboards in this Cadillac Escalade, where there had been a specific intent to clean up this area. This list, Stacey, included things like, I think there's even one statement in here, melt the bodies.
Right, there is.
Also, he had an indication of muriatic acid. He's looking to dissolve the bodies. There's a hacksaw. There's all of these things that are playing in. So, when you start to talk about insanity, when you start to talk about insanity, would anybody in their right mind, if they are insane and they're just going bonkers, are they going to make a list of things that they're going to do? I think that that's going to be brought up
Joseph,
along the
I'm
way.
glad that you brought that up because I agree with you that that is going to be a key part in proving whether or not there was intent. Timothy Jones case on a bit of a break in South Carolina while lawyers work some stuff out. So we are talking about what we have heard so far, and we are talking about the charges on the line here. Now, Jones faces 5 counts of murder for killing his own children. As we've heard, he then drove around with their bodies before disposing them in a rural area in Alabama, and then leading, or in Mississippi rather, and then leading cops there where they did find these children who you see here, these adorable children, 4 of them strangled, the other beaten to death, their bodies found in bags in this rural area. Let's quickly talk, though, again about the possible outcomes here for the defendant, because the defense will be arguing that he was insane, that he had schizophrenia, that that's what caused him to kill his own children. Will they be successful at that? We're not sure. But what are the possible verdicts he could face? Well, they could find him guilty. They could find him guilty but mentally ill, or they could find him not guilty by reason of insanity. So, David, we were talking about this a few minutes ago, but I just want to review this again. David Schoen, criminal defense attorney who's with us via Skype from Atlanta. In what scenario, then, is the defense successful in this case?
That's a good question, Stacey, and you're right on with what the possible verdicts are. The only way the defense is successful in this case is if they're able to prove by a preponderance of the evidence that at the time of the crime, under the M'Naughton rule, which is the applicable standard for insanity in South Carolina, at the time of the crime, Mr. Jones was unable to distinguish between right or wrong. That would be the only way he can be found not guilty by reason of insanity. As you pointed out, South Carolina also recognizes this defense of guilty but mentally ill. In that case, it would require a finding by the jury that he was able to distinguish between right or wrong, but at the time of the crime, he wasn't able to conform his conduct to the requirements of the law, sometimes referred to in the cases as irresistible impulse, which is another variety of an insanity defense. But in South Carolina, it doesn't get you out of being found guilty. It only finds that the defendant could have been mentally ill. That's still a guilty verdict. And in South Carolina, that still could subject him to the death penalty. So this was a device that South Carolina legislature came up with to avoid having defendants who seem to be off to some degree, found not guilty by reason of insanity, but still be found guilty, recognizing the mental health problem. And the difference here is if he were to be found guilty but mentally ill, then the immediate step would be a mental health evaluation. Afterwards, he'd go to an institution before being put into general population.
But as you said, that doesn't take the death penalty off the table.
Yeah, and there's a case in South Carolina called State versus Wilson from 1992, in which the Supreme Court of South Carolina affirmed the use of the death penalty for a defendant found guilty but mentally ill. And in 2004, a federal court upheld that consequence as well. Listen, the states all over the country and the Supreme Court are wrestling with the idea of whether a mentally ill defendant can be put to death, can receive the death penalty in the first place and or be put to death. And there's a whole variety of opinions out there on that.
And Joseph brought this up right before the break. We heard from investigators yesterday who searched the SUV which had blood stains and bleach stains and maggots crawling in it, the SUV that Jones used to transport his children's bodies. And they also found a list there which said burn the bodies, which talked about acid and other items. I mean, it was kind of a bizarre list that went in all different directions, but can a list like that be enough to prove intent and that the defendant knew what he was doing? I mean, he's jotting down steps here. He's making some kind of plan, it seems.
Again, you've raised a great point. So it plays both ways. If I'm the defense lawyer, I've got to put on an expert that shows that a person suffering from schizophrenia can very well, first of all, have moments of lucidity, but secondly, write down things like this, thoughts that have come to him, or plans. And those plans can be an intimate part of the schizophrenia. On the other hand, it makes the defendant look conniving. He bought supplies. He took great pains to cover up the crime that he committed. You might have expected to see a defendant who, if in a moment of lucidity, recognized what he did, would have been beside himself, possibly committed suicide, possibly gone to the authorities. to report with this horrible thing he's done. Instead, this defendant planned on how to dispose of the bodies, and as you say, methodically made a list and all of that. It's going to come down. You pointed this out earlier. It's going to come down to the experts if the jury is paying attention
and that was
not just so turned off.
That was my next question for you. Before we go to break and let you go, David, what will be the most key element here for the defense? If you're the defense attorney here, I mean, is it the psychiatrist that comes up and says, yes, this man definitely was insane and has schizophrenia? Is that sort of going to be their big element, you think?
100%. That's exactly it. And it's got to be very compelling. Remember, it's not just the defendant has a legal burden by the preponderance of the evidence. The defendant comes in here with a jury presented with one of the most horrific crimes, maybe certainly the most horrific crime they've ever heard about. So that's a big burden. It's going to come down to the expert.
David Schoen, criminal defense attorney, thanks so much for being with us. We know you have to go, but viewers, stick around. We'll be right back after this break with much more.